Hey, it's Brian Gormley with another edition of We're in Greater DC. I think everyone knows pretty much where we're filming this week. So if you're make it a little harder for people in DC, Montgomery, PG County, Fairfax County, Prince William. No fair guessing. Let's hold this out for somebody else who isn't in DC, and we want not the building directly behind me, but the one to my left, your right, right over there. And that's the building we're going for. So only people who have a mailing address outside of those counties, if you're not in the state, or you're up in Baltimore, or way down in southern or western Virginia, or whatever, another state entirely. Can you guess this week? What we do, of course, is run a weekly video blog. Send your guesses to support at Cornerstone Properties, homeinfo.com. The first person to guess our filming location wins a free prize each week. So that's it. And in terms of the substance, we want to kind of bring together some of the things that we've been talking about over the last 8 or 10 months in terms of securitization and foreclosure defense and some of the mortgage fraud issues and so on, all in one in this video. So a lot of the defenses now, in terms of foreclosure defense, that attorneys are putting forward involve some sort of standing or fraud defense with respect to the original loan and what's happened to that loan and the mortgage since its origination. One very common theory is that there's a chain of title issue. In other words, because the loan was securitized, it was put into a trust with a whole bunch of other loans, and it wasn't properly transferred from the originator to the securitization aggregator to the securitization trustee and so on, and now to the party who's trying to foreclose. The foreclosure is illegal. It's not authorized. It's a fraud on the court, and in fact, there's no authority to actually sue the homeowner. And of course, in Maryland, DC, Virginia, they're non-judicial states, so or at least quasi-non-judicial states. Not like Florida, where you got to completely go in the court to foreclose. You can actually have a trustee sale, and as a result, there's a lot more latitude to get away with some of these shenanigans, where you hear about the robo-signing and other such things with the people without standing foreclosing. Another thing is if the mortgage and the note have been separated. At least the theory goes, if the security instrument securing the primary obligation to repay has been transferred in one place and the note has been transferred in another place, you've suddenly bifurcated the collateral from the underlying loan obligation, and therefore rendered that security instrument void. So, in other words, in layman's speak, the deed of trust is no more. The entity that's secured, or at least has a payee obligation, or payee, I shouldn't say obligation, payee right to receive payments out of the note, isn't secured by the mortgage, so they can't foreclose. So that's at least the theory. So a couple of interesting points. Of course, there's always the fraud claims. There's gross negligence in the origination. There's TILA claims to rescind the transaction entirely. There are a lot of different things there that can be argued and put forward when you've got a potential foreclosure in front of you. And these are the sorts of things that we would use to argue in a short sale context or otherwise foreclosure defense to advocate for the homeowner. So good stuff. It's obviously a lot of nuances with the UCC. Article 3 of the UCC comes into play with respect to negotiable instruments and secured parties, and then of course state law as well, foreclosure procedure, and what folks are authorized to do and allowed to do, as opposed to what they try to do and getting away with some of these foreclosure tactics. So that's it for me. Don't forget to send your guesses. The building on my left to support at Cornerstone Properties, homeinfo.com. Don't have a mailing address in the local area, and I will see you on another video. Bye-bye.